Now, whether you think Roundup causes cancer or is perfectly safe, do you have a right to sue for an allegation that it does? More specifically, for the case of Monsanto versus Durnell, can federal law prohibit you from suing in state court? That is a question before the Supreme Court. Monsanto Company manufactures and distributes Roundup, a glyphosate-based herbicide designed to control weeds. The EPA has repeatedly evaluated glyphosate and repeatedly concluded that glyphosate is not likely to cause cancer. EPA's assessment is shared by many other regulatory bodies around the world. Before we go any further, let's talk about the EPA, the Environmental Protection Agency. Now, according to their website, the mission of the EPA is to protect human health and the environment. There's just one problem with the EPA's mission. It's not constitutional. See, under the 10th Amendment, we find the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively to the people. The power to protect human health and the environment is not delegated to the United States anywhere in the Constitution. However, the question at hand is not about the EPA's mission or whether or not Roundup causes cancer, but about the labeling requirements for it to be sold in interstate commerce. See, in accordance with the EPA's views that glyphosate is not likely to cause cancer in humans, EPA has not required labels on glyphosate-based pesticides like Roundup to include a cancer warning. However, that doesn't mean Congress has the legal authority to make EPA the determiner of whether or not something is safe for humans. The problems in this case are much worse. In 2019, John Durnell sued Monsanto in Missouri State Court, alleging that he had used Monsanto's Roundup product for about 20 years and that they had caused his non-Hodgkin's lymphoma. As relevant here, Durnell brought a failure to warn tort claim, asserting that Monsanto should have included a cancer warning on Roundup's label. Now, Mr. Durnell has a grievance. He thinks that his non-Hodgkin's lymphoma was caused by his 20-year use of Roundup. He claims that Monsanto violated state law, since the case was brought in state court, because their label failed to warn him of this particular danger. Now, whether or not he has evidence to prove his case is not the issue here. Rather, it's whether or not he gets his day in court. A jury agreed and awarded Durnell more than $1 million on the failure to warn theory. On appeal, the Missouri Court of Appeals affirmed. So both a Missouri jury and the Missouri Court of Appeals agreed that Mr. Durnell did have a legitimate grievance and that his redress should be $1 million. Even the Federal Appeals Court agreed. The Court of Appeals rejected Monsanto's argument that the Federal Insecticide, Fungicide, and Rodenticide Act expressly preempted Durnell's failure to warn claim. The court granted certiorari. See, until SCOTUS, every court agreed that Mr. Durnell had a legitimate grievance. However, the Supreme Court would disagree.